overqualified. They all graduated from law school. Thank you so much for your help, everyone. If you're both ready, we'll do a quick sound check for Justice Apple, who's participating by Zoom. We'll start with Mr. Andrew Howie, if you want to give the first sound check.
Hello.
Not hearing you, Mr. Not yet.
There we go. It's green now. Can you hear me now? You're on.
I surely can. Thank you, Counsel.
Excellent. Thank you.
That's why we do this. Thank you. All right. And Mr. Geerdes, if you'd like to do the same.
Good morning, Justice Apple.
You're gonna,
Good
are you going
morning.
to sit during your argument?
I will stand.
Okay, maybe try that because our microphone needs to pick you up.
Check, check.
Thank you very much. I appreciate it.
Thank you. And you may begin when you're ready. Actually, Mr. Geerdes, you are the further review applicant, correct?
Correct.
Yes, go ahead.
May it please the court, Mr. Howie. This is a short will, but it has a variety of different components to it which create interesting legal issues. But there is an overriding theme, I think, on all of those issues, and that is how much respect should we give to the intent of a testator? I'm going to concentrate on two issues. I'm going to concentrate on the restraint against alienation issue, and I'm going to concentrate on what the word request means and whether that is in fact a request or whether that is in fact a direction. The time has come, in my view, for the court to reassess the ancient rule which restricts alienation of real properties. I think that the restatement provisions, and there are two of them, one you've already adopted in the co-college case, and the restatement provision which is contained in the restatement of servitudes has a much better way of addressing the problem. In 1880, when this court adopted the McCleary rule, I think the restraints against alienation made good sense. But the Iowa of 2020 is not the same as the Iowa of 1880. Specifically, in 1880, we didn't know where our cities were going to be and what they were going to look like. For example, if you looked at the census records, in 1880, the population of Des Moines City was 22,500. The population of Des Moines County, where Burlington is, was 33,000. Now the population of Des Moines County is only 40,000 and declining, but Des Moines City is 203,000 and rising.
A problem that, is raised by the other side, and that is, was this idea of adopting the restatement third raised below. And the reason why I think it's important that it had to be raised below is because it adopts a reasonableness test. And in order for us to say that restatement third should apply, there should have been an opportunity for the parties to litigate reasonableness below, which there wasn't because this 1880 rule was applied. So was it raised below?
Yes, I believe it was. Certainly the court below decided that it was a forbidden restraint on alienation. I think the court certainly knew of the co-college case and knew of the issues surrounding whether restraints against alienation were going to be continue to be enforced or not. I think was very much in the atmosphere surrounding the case.
Counsel, can you why are the changing demographics of the state material to the rule on restraint on alienation? I guess I wasn't following what your point was.
Because Vera's farm, I gave you a map showing where it is a very rural farm. It is being farmed very efficiently by Mr. Brooks, and it is nowhere near any city where it's going to be, certainly not in the next 20 years, going to be developed for anything commercially or anything other than agriculture. It's at its highest and best use. The restraint against alienation test as adopted in McCleary was adopted because it was felt at that time that we needed to be open for development. And that makes sense because the restraint on alienation may unreasonably deter development. For example, if Vera's farm was adjacent to Ankeny or Des Moines, it might well be reasonable to find that a restraint against alienation is improper in that circumstance.
But doesn't that concern still hold true? I mean, aren't we always concerned about development? And somebody 100 years from now is going to make the same argument you're making about changing demographics and how we want to populate the state more. I don't see why that counsels it that way.
Vera was wise, and we're talking about 20 years. Okay, that's the time constraint that Vera imposed. And it is very safe to say that a farm which is located 3 or 4 miles outside the city of West Liberty, which is also not growing, as you can see from the 2 maps that I have, is not going to be ripe for any sort of development other than farming in the next 20 years. If Vera's farm was in Des Moines or next to Ankeny, we'd have a completely different analysis.
Counsel, similar to what Justice Mansfield was asking, so who makes that reasonableness determination? Did the district court make that? And if it did not, then are you asking us to make that, or would it have to be remanded?
I don't think it needs to be remanded. I think that the record is quite, as far as these sorts of cases go, it's fairly extensive. We know a lot about Vera. Her will tells us a lot about what Vera wanted to do as far as preserving her farm, et cetera. So I think to the extent that reasonableness needs to be determined, I think it can be done based on the record by this court.
Counsel, does the Co-College case really help much to this case? You know, that was a case involving the transfer of artwork to a charity, and here we're talking about real property to a private person. I mean, aren't those 2 pretty different things in terms of the analysis that we would undertake here?
No. The Co-College case could have been decided based on the Sisters of Mercy case, which goes back to 1937, I believe it is, which says that a restraint on alienation based on a gift to a charity is enforceable. The court didn't decide that case based upon that old precedent. It went out of its way to adopt the restatement. And of course, as it's stated in the brief, the restatement applies to both real and personal property, and it applies to donative transfers, which include wills and other sorts of testamentary transactions.
Is there anything unique about the Iowa maintains its land records, title, et cetera, compared to other states that would counsel in favor or against adoption of the restatement rule?
If the restatement on donative transfers or servitude?
No, sorry, the reasonableness rule that you're asking us to adopt in Restatement Third.
In a way, yes, because I think what we're seeing slowly coming into play are things like conservation easements, and we're seeing the need to preserve certain property for environmental reasons. So, for example, in that case, if we wanted to preserve a stand of bur oak trees, I think that the enforceability of a restraint against alienation, which kept those bur oak trees with a sympathetic owner, would be, very reasonable. It's something that we're seeing more of as Iowa becomes more urban, and that's going to continue.
Let me try another argument. Could one argue, looking at what's the statute? 61424 imposes limits on use restrictions, correct? And given that the legislature thought it was necessary to limit use restrictions, but didn't adopt any legislation to limit restraints on alienation, doesn't that mean that implicitly the legislature endorsed that line of cases going back to 1880, that use restrictions alienation restrictions are per se invalid, and therefore we don't need any legislation to limit them?
I don't think that follows at all. For example, if the legislature was concerned about that, one would have expected them to take action to legislatively overturn the Co-College case. But that's not happening. It seems to me what they're doing there is they are saying, especially in the area of probate, that a testator's intent is very important. And you can go through the cases and you see these things that the pole star of this court's purpose is to ascertain and implement the testator's intent. That line appears in all of these cases.
Except in Co-College, we said that the rule announced in that case was an exception to the restraint on alienation. We reaffirmed the same rule that we've had since McCleary and just noted it doesn't apply with respect to donative transfers in that case of personal property.
If that were true, respectfully, you would have decided the case based on Sisters of Mercy. But instead you
But that is what it explicitly said in the opinion.
Well, you adopted the restatement on donative transfers. And
I wrote the opinion, and it's been taking a few lumps, so I'll try and defend it. The restatement third is the more up-to-date law in the area of donative transfers to charities. This was a donative transfer to a charity. In that case, the restatement third was consistent with our past law, but I don't see how that case, as Justice McDermott suggested, I don't see how that case necessarily has any bearing on this case, does it?
it carries out and highlights the importance of the testator's intent. I believe the term you used is something along the lines that the testator's intent should be given enhanced importance, if I'm paraphrasing that correctly. And when you interpret the gift document, that is what you're supposed to be doing?
That was a question of interpretation, not legal validity or invalidity. There was no issue, I guess there was a secondary issue, but the primary issue was just, what were the terms of the gifts? Did the paintings have to stay in the library, or could they be sold?
Well, I think it went further than that. Certainly when the restatement provisions that you adopted in that case went further than that, because they clearly apply to wills. They clearly apply to things other than inter vivos gifts. And we're talking about the current and better view of alienations, and then we have to, I think, address it in the servitude restatement, which says, this isn't a one-size-fits-all complete elimination of restraints on alienation. We're going to look at the particular transaction and determine whether or not it's reasonable. And that's a far better approach, especially when you're dealing with a state like Iowa, which is trying to figure out if it's a rural state or if it's an urban state and what we're going to do, you can't have a one-size-fits-all rule.
So counsel, let's say that I might agree with you that transfers of real property, when it has, when it involves a transfer, maybe not to a charity, but for a charitable type purpose, right? For an environmental reason or a conservation reason, might be one basis where we would look at, you know, the purpose of the transfer and there might be a public policy reason why we might want to permit those sorts of transfers. Here, there doesn't seem to be any basis, at least in this record, that has been made that I can see, and correct me if I'm wrong on that this was for any of those purposes. Instead, it was just going to continue to be rented for farming.
I disagree strongly. There's no doubt in my mind when you read the will that Vera wanted that farm to continue. She gave her, and for you non-farmers, she gave her cows to Terry Brooks. And cows are breeding stock. They're not things that you fatten up and take to the slaughterhouse. They're your herd that you get calves from each year. And
Counsel, before your time runs out, I would like you to, as you're talking about the issue of farming, to touch on your second argument involving the request that they continue to allow Terry to farm. Could you please touch on that?
I think that this is a case which is very hard to distinguish from the Hansen estate case as far as what the term request means. In Hansen, we had a testator who was in an ongoing farming relationship with one of his sons. There was rent being paid and other considerations going on. The testator requested, that's the term in his will, requested that his tenant have an option on the farm. The other beneficiary said, request is a request, it's nice, but we're not gonna honor it. The court said, we gotta look at the overall picture of the will. And did the testator really want to wipe out this existing tenant relationship, or did she want it continued? Getting back to the cows.
Counsel, where was that issue raised in the district court?
about the request issue?
About the request that he be allowed to continue.
The request issue was raised below, and the court converted that into this. The court ruled that it was precatory and that it wasn't enforceable, and then converted all of Terry's rights to this 90-day right of first refusal. But I think when you look at Vera's will, including the fact that she gave her cow herd to Terry Brooks as well as her machinery, along with the direction that he have an option to buy the farm, and a request that the existing lease arrangement continue, makes this a very clear case. I'm running out of time. That
You may briefly wrap up since you'll have a chance to reply.
that Vera very much wanted the existing farm operation to continue, very much wanted all of the provisions of her will to be carried out, and not just some of them. Thank you, I'm out of time.
Thank you. Mr. Howie. Yeah, I don't think you're on.
I hit a button.
There you
There
go.
we go. May it please the court and my opposing counsel. My name is Andrew Howie, and I represent Tom and Beth Coronelli, who are the beneficiaries under Vera Cawiezell's will. The record is quite clear, and to my opposing counsel's credit, he has thrown a tremendous amount of issues at this case to try to get Mr. Brooks what he wants. But as the district court found, and as the Court of Appeals correctly found, none of those legal issues are simply correct. The Court of Appeals got it right, the trial court got it right. So let's jump to the heart of the matter. What did Vera do in her will? She owned 150 acres of property, which she then devised to my clients, Tom and Beth Coronelli. That's it. Except she put a restriction on it. And she said that the Coronellis could not sell it except to their immediate family for 20 years. That directly violates this court's well-established rules since 1880 of the rule against restrictions on alienation. As a result of that, what do the executors want? They want this court to adopt the restatement. As Justice Mansfield brought up, that was not brought up in the trial court level. And for this court to consider completely upending 140 years of precedent established, we need, number one, a better record, but frankly, we don't need a record in this case because there's no reason to overturn that precedent. All the restatement does is add a kind of a reasonableness standard to it, but there's no basis as to why this court should adopt it. Because the restatement still says restatements of alienation, well, they can be considered and sometimes, and there shouldn't be a blanket rule, and so therefore we want to do a reasonableness test.
That's a question. Could the same effect as a restraint have been achieved simply by putting a reversion in the will?
No. Because as the McCleary case, the Gunther case, the sisters case basically say, even if there's a reversion, a restraint on alienation is not permissible. It's one of the few bright line rules that I've been able to encounter in my legal career. And it's a straight across bright line rule. It's worked the state well for 140 years and should continue in perpetuity because of that.
How would the case have been tried differently if there had been an express, crystal clear, hey, to the trial court, let's adopt this restatement third?
Well, then what would have happened is that if we adopt the restatement, then the court would have to go into a whole evidentiary background as to what's reasonable, what is not, which was, of course, is then bound by what Vera's intent was. Because, and now we're kind of getting into what the district court did. What the district court did by finding that the restraint on alienation was invalid, pursuant to that old rule, then it went into, well, wait a minute, Vera still wanted to give Terry Brooks something, okay? Didn't give him a property right, much of a property right. The will clearly gives the Coronellis, but for that 20-year restriction, a fee simple estate in that farm. But to preserve Terry Brooks giving him something, the court interpreted Vera's language as basically saying, he gets a right of first refusal. My clients consented. The executors consented. That's why the Court of Appeals rejected their argument on appeal, because the executors accepted that in the district court level. Now all of a sudden they changed their mind and wanted the Court of Appeals to overturn it, and now they want this court to overturn it. That, based upon the case law, which the Court of Appeals correctly cited, is, I think, correct, and this court should affirm. And so getting to Justice Waterman's point, how this would have been done, I think it just clearly would have been is, okay, how do we balance this 20-year restriction? Is it reasonable based upon what Vera wanted to do? Well, then when you look at the restatement, this is what's so interesting about my opposing counsel's reliance upon Restatement Servitudes 3.4, is when you get into the comments, when you get into the multitude of cases that are cited in that, what is clear is when you have a long period of time of restriction that automatically goes towards the unreasonableness. For example, I found 4 cases. One, and these are cited in the restatement. A California case said 3 years was too long. A Tennessee case said 20 years was too long. A Texas case said 25 years was too long. And then Maryland case said 4 years is too long. We have 20 years. And so therefore, the 20 years was blatantly unreasonable. And then let's get back to where we were. Why did the Iowa Supreme Court get it right in the year 1880? It's because this court and the Iowa legislature has consistently said over and over and over again, we do not want to have weird restrictions and weird covenants clouding titles for years or decades. We want the marketability of titles. That's why 614 was come in, and they said we want to clear the stuff up, limiting it to 20 years, and so on and so forth. So across that line, again, the trial court got it right, the Court of Appeals got it right.
Counsel, do you think the issue on whether or not they had to, your clients, the Cornellis, had to continue leasing to Mr. Brooks, was that preserved below? I thought the only thing that district court ruled on was the right of first refusal.
I agree, Your Honor, and I don't believe it was preserved. But if this court finds it was preserved, the leasing doesn't apply. Why is that? Again, let's look to what Vera exactly wrote. Terry Brooks has been leasing the farm from me for under a sharecrop agreement, and I would request that the Cornelli family continue leasing to Terry Brooks under favorable terms for his benefit. That's what refers to the lease. And as this court and the Court of Appeals in published decisions has said over and over again, that request was to the Cornellis. Requests of that type are precatory. Precatory are not compulsory, they are not mandatory. It did not create an obligation in the Cornellis that they had to lease to the Brooks. And in fact—
Counsel, and that's what the district court found, right? Was
Yes.
that he did actually make a finding it was precatory. If we were to disagree with that and say that that was actually mandatory language, would you consider this an alienation restriction or a use restriction, and would it be valid then?
Very good point, Your Honor, and I believe it would be an alienation restriction. Because again, what does the alienation statute, the rule against restrictions on alienation provide? We want to provide free marketable title to landowners, to future sellers, and so on and so forth. And so what this court, the Court of Appeals, and the legislature has continually considered is, we want to have free title. And so therefore, who would buy it? For example, say the Cornellis wanted to sell it. That's going to severely restrict the marketable title if a future buyer knows that, all right, I've got to lease it to Terry Brooks for 20 years or for 90 days or 180 days, where Terry Brooks's rights are already protected under, when you can terminate a lease and so on and so forth.
And you raised a good point about, my question was, if it was considered a use restriction, how long would that be? And that was kind of my concern is whether the terms, I suppose, of what that lease would be and how, if it would have to last for the 20 years or.
I don't believe it would last for the 20 years. Again, that I think
So could that be a valid use restriction then, that as long as they owned it, they were required, or that they were required to lease it?
No, I don't believe that's a proper use restriction, Your Honor, to get straight to the point. Section 614.24 simply does not apply. And with that, and also what the legislature did is—
And explain why.
Well, because the legislature in 614.25 expressly defined use restrictions. And leasing to other properties is not one of them. And so therefore, as the old axiom that this court has applied many times, when there's a list of things, if they don't list it, that means they didn't mean to, which gets around to, again, my opponent's continual argument that somehow 614.25 upended the rule against
the list includes a prohibition on rental use, so why couldn't it include a requirement to rent it?
Well, because that's an opposite. The legislature was not that explicit, and to read that kind of broad definition into the use restrictions, I think, just does not go to the actual language used by the legislature. In other words, if they wanted to compel a positive, saying you shall lease, certainly the legislature would have said that, and they didn't say that. So, in summing up, since I can't even tell, I'm getting old in my eyesight, I can't read
You
anymore.
have 5.5 minutes.
Okay, thank you, Your Honor. With this basis is we have severe preservation of error issues. The trial court and the Court of Appeals applied the 140-year rule against restrictions on alienation. The leasing simply does not apply. And I also want to just make sure, was it an option versus a right of first refusal? Okay, let's touch on that. The district court interpreted the Vera's will as granting as a remedy to Brooks, because the restriction on alienation cut out the 20 years, gave him a right of first refusal. Why is that not an option? Well, It's not an option because to exercise an option, Vera would have had to, in her will, expressly give Brooks the power to compel the Coronellis to sell it to him. The power to compel to sell is one of the key attributes of an option. Vera does not say that. Vera does not say, hey, you get this property, but you have to sell it to Brooks. She didn't say that. All she said was, if you sell it, then you've got to give him first option. Well, as this court and the Court of Appeals has routinely found that even though testators or deed drafters use the word option, they look to it to say, well, what they really meant to say was first right of refusal. And the key consideration is the power to compel. Brooks has no power to compel the Coronellis to sell it to him. Therefore, it's a first right of refusal. And then what I do, what is...
Correct me if I'm wrong, and everybody agreed to that at the district court.
Yes, Your Honor.
Correct? I believe the litigation was about how the right of first refusal was to be exercised. I don't recall there being an argument below that this was an option. Or is
Only
that,
mildly, Your Honor,
okay,
and
correct
that's...
if I'm wrong.
Yeah, Justice McDonald, maybe I'm overreading my opponent's arguments, but I just want to cover all my bases just to be sure. But you're right. Again, the executors acquiesced, and they said, okay, it's a first right of refusal. Well, now let's just determine the terms of that first right of refusal. And the district court's determination of if and when the Coronellis decide to sell it, they've got to give Brooks 90 days notice. That is perfectly fair. That fulfills Vera's intent to provide Brooks at least some protection as to what is going on. And therefore, again, the trial court did everything right. And the Court of Appeals, in its decision, did everything right. And so really, unless Your Honors have additional questions, then I would ask that the court affirm the trial court, affirm the Court of Appeals, and as the disposition of this case. Thank you.
Thank you, Mr. Howie. Mr. Geerdes, your response?
Thank you. I think that Mr. Howie brought out the weaknesses of...
I'm sorry, Counsel, I can't hear you. You need to be closer to the mic. Thank you.
Actually, I don't think he had it on, so you really couldn't
Well-
hear him. There you go. Nope, it's still not green, I don't think. There.
Okay, I think it's green now. Can you hear
Yes.
me, Justice Apple?
I can. Thank you so much.
Mr. Howie demonstrated what's going on here. His clients are cherry-picking the will. They like the parts that benefit them. They don't like the parts that benefit others. Prime example, the will couldn't be any more clear about granting Brooks an option. It's not a request.
On that point, counsel, are you familiar with the Reynolds case from 1969? We actually gave that as an exact example. If a bequest to Blackacre to A and an option to B are inconsistent and would invalidate the option.
But you have to look at Vera's will in the context of the entire will. And this isn't a bequest just to the Coronellis. This is a bequest to both Coronellis and to the Brooks. She gave Brooks an option. She gave the Coronellis, call it the rest of the property. It's not technically a remainder, but she certainly gave both Brooks and the Coronellis an interest in the property, and her intent, I think, is very clear in her will.
Well, I don't know that it's very clear when it says first option, which does seem to sound more like a first right of refusal, but it seems like that you want to reverse even the order of the will when the will starts out by devising and bequeathing the property first to the Coronellis.
The Hansen case does a good job of explaining the history of this sort of problem, and it very clearly covers the issue of what order in the will means. And that's not the controlling factor. The controlling factor is the intent of the testator. The clients of Mr. Howie want to eviscerate much of what Vera obviously intended. I don't think there's any doubt about that at all. And it's really hard to be sympathetic to the Coronellis, because for the worst case scenario for them is that for 20 years, they get the rent from the property. They have 150 acres, minimum $300 an acre cash rent. So that's $45,000 a year for 20 years, and then they can sell it.
On the provision about continuing to rent, if we were to find that that was mandatory, is it your position that that is for a 20-year period, that they would be required to rent it? And so then if they did sell it and Terry did not elect then to purchase, would that requirement to continue to rent with him continue with that sale?
I believe so, yes. And it's a cash lease arrangement, so, excuse me, it's a crop share arrangement, so we know what the terms are. So it's hard to be sympathetic to the Coronellis here, but they want more than what Vera gave them. Getting them a farm that's worth $1.5 million that they can sell free and clear in 20 years isn't good enough. They want more, and I think when you look at the will, especially the residuary clause, which we haven't talked about, but Vera was obviously a very generous person who wanted her considerable assets to go to her friends and to charities. She didn't want one person to take advantage of the others. She didn't want to benefit just the Coronellis. Even though the Coronellis are always going to be the major beneficiary of her estate, in my opinion, the Coronellis need to recognize that Vera wanted to help others too. It's not just their farm to do what they want. With that, unless you have some more questions, I think I have summed up my position.
Thank you, Mr. Geerdes. The case of the estate, by the way, how is it pronounced? Oh, I did not say that right. The case of the estate of Cawiezell is hereby submitted, as well as the two other cases without oral argument, State versus Holmes and State versus Hahn. Court is adjourned for the morning. Thank you.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.